This case starts with what might seem like a routine DWI hearing, but as the facts unfold, it becomes a powerful example of how repeated bad decisions can eventually catch up with someone in the criminal justice system. Today we're looking at not one, but multiple felony DWI cases involving defendants who had already been given chances by the courts before finding themselves right back in front of a judge. What makes this hearing especially striking is how quickly the courtroom establishes a pattern. Prior convictions, probation violations, and yet another arrest for the exact same offense. As the judge walks through the history of these cases, you'll hear references to convictions stretching back years. You'll also see how a misdemeanor offense can transform into a serious felony when prior convictions pile up. The consequences become increasingly severe, and the legal system begins treating the behavior as an ongoing public safety threat rather than an isolated mistake. Pay close attention to the warnings issued from the bench. The judge doesn't just hand down sentences. He explains why these defendants are facing prison time and what could happen if the cycle continues. It's a reminder that driving while intoxicated isn't viewed solely as a personal risk. It's seen as a danger to everyone sharing the road. One defendant is about to accept a 5-year prison sentence after admitting guilt, while another finds himself facing the consequences of violating probation for the same type of offense he was previously given a second chance for. The question is simple. How many opportunities should someone receive before the court decides enough is enough? Let us know your thoughts as we watch this dramatic courtroom proceeding unfold.
On 25 CR 1491, does the defendant, Escar Wayne Davis, that's you,
Yes, sir.
here with your attorney, Mr. Kimber, and the state's attorney, waive a formal reading of the indictment and arraignment here, which are parts 1 and 2 of this indictment. And can we proceed in summary?
So wait, we may know.
In summary, sir, paragraph 1 alleges that on or about September 11th, 2024 in Jefferson County, Texas, you committed the offense of operating a motor vehicle while intoxicated in a public place. Do you understand what you're charged with there?
Yes, sir.
Now, that would be generally a misdemeanor, except paragraph 2 goes on to allege that you have two or more prior convictions. It states that on October 19th, 2011, out of County Court at Law 3 of Jefferson County, Texas, you were convicted of a DWI. And in 2012, in this criminal district court of Jefferson County, Texas, you were convicted of another operating a motor vehicle while intoxicated. So paragraphs 1 and 2 constitute a third-degree felony. Do you understand what you're faced with in this particular situation?
Yes, sir.
You must have had there must be another DWI in there.
My second one with child passenger. My second one.
Okay. Yeah, it's not alleged in here. It only takes 2 prior to become a third-degree felony, but you've got this felony was already in here, which meant you had 2 prior somewhere. All right, this indictment, paragraphs 1 and 2, constitute a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000.
The legal significance of what's happening here shouldn't be overlooked. The defendant isn't just admitting to a new DWI charge. He's admitting to a felony-level offense because of his prior record. In Texas, repeated DWI convictions can elevate what would normally be a misdemeanor into a third-degree felony, dramatically increasing the potential punishment. That's why we're hearing discussions about prison terms ranging from 2 to 10 years and fines that could reach $10,000. What's also notable is that the defendant appears to recognize his history. When prior convictions are mentioned, there's no attempt to deny them or challenge the allegations. Instead, the focus shifts directly to the plea agreement. This often indicates that both sides have evaluated the evidence and concluded that accepting a negotiated sentence is preferable to risking a trial. Do you think 5 years is a fair punishment for a repeat DWI offender? Or should the penalties be even tougher?
As you understand. The punishment range.
Oh, yes, sir.
An agreement's been reached. In your case, you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, sir.
So how do you plead to this indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges those prior convictions of DWIs, County Court in Law 3 of Jefferson County in 2011, and in this criminal district court of Jefferson County, Texas in 2012. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily and because they are true as they are stated in the indictment?
Yes, sir.
I'm going to show you what's marked as States Exhibit 1 here. Would you sign that document? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. It's been read here. You've read them. You were guilty of the crime charged in any lesser included offense. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived. Hello. Okay, if nothing further, I'm going to find that you are pleading guilty and true respectively to paragraphs 1 and 2, which constitute the third-degree felony of operating a motor vehicle while intoxicated. There is sufficient evidence supporting your guilty plea from paragraphs 1 and 2 in this indictment during this hearing, based upon State's Exhibit number 1 admitted into this hearing to support your guilty plea, to find you guilty beyond a reasonable doubt. And you were giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. I now find you guilty beyond a reasonable doubt of this third-degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case up to this point. Please be careful. The next time it gets enhanced, if it's a DWI, again, it gets bumped up to more than just a third-degree felony. So be responsible.
That final warning from the judge carries more weight than it might initially seem. Judges frequently use sentencing hearings to emphasize accountability, but here the message is crystal clear. Future offenses could result in even harsher consequences. The court isn't simply punishing past behavior. It's attempting to prevent future tragedies. What stands out is that this defendant has already accumulated multiple DWI convictions over the years. Each conviction represents a prior encounter with the justice system and an opportunity to change course. Yet the pattern continued until it resulted in another felony conviction and a prison sentence. For many viewers, this raises an important question about deterrence. At what point does punishment stop being enough, and what additional measures might actually prevent repeat offenses? That's a debate courts and lawmakers continue to wrestle with across the country.
As an operator of a motor vehicle. Anything else to add? That's all.
That's correct.
Lauren? Yep, you're going to have a seat and you're placed into custody. All right, we call 2 cases involving State of Texas versus Shermy James Arno. Is that you?
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
Yes, sir. One is the motion to revoke, and the others.
I don't have anything in my queue here. Y'all sent it, right? Yeah. And in 18-29175, does the defendant, who is here with his attorney, Mr. Dusler, waive formal reading of the motion to revoke probation? Can we proceed in summary?
Yes, sir.
In summary, sir, this motion to revoke probation filed on March 18th of this year states that on December 17th, 2018, in this court, you were sentenced to 6 years in prison, and that was suspended. You were placed on regular probation for 10 years for the third-degree felony of operating a motor vehicle while intoxicated. Is that true?
Yeah.
What's he pleading to?
Your Honor.
1. Allegation 1 states, and his name is misspelled. I'm going to correct it. Any objection?
No, sir.
Allegation one states that you committed the offense of operating a motor vehicle while intoxicated, a third-degree felony or more on or about February 6, 2026 in Jefferson County, Texas, in violation of condition 1 of your probation order. Is that true or untrue?
Now we're seeing a very different but equally serious legal situation, a probation revocation proceeding. Probation is often described as a second chance, allowing someone to remain in the community instead of serving time behind bars. However, that opportunity comes with conditions, and one of the most basic conditions is avoiding new criminal offenses. According to the allegations being discussed, the defendant was already on probation for a felony DWI when he allegedly committed another intoxicated driving offense. That's about as direct a violation as it gets. Notice how the judge carefully explains the consequences of pleading true to the violation. Once that admission is made, the court gains substantial authority to revoke probation and impose the previously suspended prison sentence. This is a critical moment because the defendant isn't just facing a new case. He's potentially losing the benefit of a sentence that had been suspended years earlier.
Pleading true voluntarily and because it is true as it is alleged. In the indictment that you pleaded guilty to back in the old days in 2018, this states in paragraph 2, when you were placed on regular probation, found guilty and placed on regular probation in this court for this offense, that you were convicted in 2001 out of County Court of Law number 2 of Jefferson County 2. On November 7th, 2011, out of County Court of Law number 3 of Jefferson County, convicted on November 7th, 2011, out of County Court number 3 of Jefferson County, Texas. All operating motor vehicles while in public places, DWIs. You pleaded true to that earlier, and are you continuing to replead true to those allegations as you pleaded true to in 2018 for those prior convictions or this case? So once again, that would constitute a third-degree felony as alleged in the motion to revoke probation that you were and pleaded true to and were placed on probation in December 17th, 2018. Now with this new case on February 6th, 2026, as alleged in paragraph 1, the same violations of prior DWI convictions are expressed and used from this indictment, and all of that is true and correct, which would count. Is that true? Which would mean that you committed third-degree felony of operating a motor vehicle in a public place while intoxicated on or about February 6, 2026 in Jefferson County, Texas. And that is a violation of condition 1 of your probation order, which states commit no offense against the laws of this state. Do you understand that a plea of true is enough to grant a motion to revoke probation violation as in allegation 1 of this motion to revoke probation by a preponderance of the evidence or greater? That would be enough to revoke your probation. Your probation can be revoked and you can be sentenced to no less than no more than 6 years confinement in prison. Knowing that, do you insist on pleading true to that?
Yes, Your Honor.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading guilty.
Listen closely to the structure of this agreement because it reveals how interconnected criminal cases can become. The defendant isn't simply resolving one matter today. The court is addressing both a probation revocation and a brand new felony DWI case. The negotiated outcome calls for 5-year prison sentences that will run concurrently. For viewers unfamiliar with courtroom terminology, concurrent means the sentences are served at the same time rather than one after another. If they were consecutive, the total amount of prison time could be significantly longer. Even so, a 5-year prison sentence remains a serious consequence. It's also worth noting that the defendant is waiving important rights, including the right to appeal if the judge follows the agreement. These decisions can have lifelong consequences, which is why judges spend so much time ensuring defendants understand exactly what they're agreeing to.
An agreement's been reached, your probation would be revoked, you would be sentenced to 5 years in prison. This would be running concurrently with at least one other case, 26-0888. Then that is the next DWI third-degree felony that will be taken up in this new case. Is that your understanding of the plan here?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand? You've marked the State's Exhibit 1 in that case, cause number 18-29175 with the motion to revoke probation. Did you sign that document, understand it, and discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. This states you are waiving all appeal if I follow this agreement, which I intend to do. I'm going to postpone that just for a few moments. I'm going to go to 26-0888. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
Yeah.
In summary, this states that on February 6th of this year, 2026, in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated. Is that true and correct?
Yes, sir.
Paragraph 2 goes on to allege that you have 2 or more prior convictions of DWIs. On October 10th, 2001, a conviction out of County Court of Law 2 of Jefferson County, Texas. November 7th, 2011, in cause number 282307 out of County Court of Law 3 of Jefferson County, Texas. And on November 7th, 2011, in 286151 out of County Court of Law 3 of Jefferson County, Texas, another DWI. Are those allegations true and correct as they are alleged?
Yes, sir.
Are you pleading true and correct to those allegations voluntarily and because they are true?
Yes.
And how do you plead to paragraph 1, guilty or not guilty of this operating a motor vehicle on a public place while intoxicated on or about February 6, 2026 in Jefferson County, Texas? Are you pleading guilty to that?
Yes, sir.
Are you pleading guilty voluntarily and because you are indeed guilty?
Yes.
Then again, you're facing a third-degree felony, no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
And again, the sentence in this case, I gotta change that. That's not a 6, it's a 5, right?
It's fine.
Okay.
This portion of the hearing highlights just how much prior criminal history can influence the outcome of a case. The prosecution isn't relying solely on the new DWI allegation. They're also presenting multiple prior convictions dating back years, creating a record that demonstrates a repeated pattern of similar conduct. From the court's perspective, repeat offenses often indicate that previous punishments failed to change behavior. That's one reason felony enhancements exist in the first place. The justice system generally reserves its harshest penalties for offenders who continue committing the same crimes despite prior convictions and warnings. As the defendant enters another guilty plea, the courtroom atmosphere feels less like a dispute over facts and more like a reckoning with the cumulative consequences of years of repeated decisions. It's a sobering reminder that criminal records don't disappear when a sentence ends. They often shape future outcomes in significant ways.
The agreement is that you would be pleading guilty, sentenced to 5 years in prison to run concurrently with the preceding case that we just dealt with, 29175. Is that your understanding? If I follow this agreement and the one before, you have no right of appeal. Do you understand?
Sure.
How do you plead to paragraphs 1 and 2 constituting third-degree felony of operating a motor vehicle in a public place while intoxicated, in this case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked the State's Exhibit 1 here. Did you sign that? Understand it? State's Exhibit 1 are the contents true and correct?
Sure.
State's Exhibit 1 tendered into evidence without objection admitted. And again, this states you are mentally competent to enter your guilty plea here in 26 CR 888, this third degree felony, voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, where you were giving up your rights to a jury trial, the right to the appearance, confrontation, cross-examination of witnesses. I now find you guilty beyond a reasonable doubt of paragraphs 1 and 2 of this indictment, constituting this third-degree felony of operating a motor vehicle in a public place while intoxicated. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice, serve a term of 5 years. These two sentences shall run concurrently. Do you understand what's happened here, sir? You've had enough tries with this. Don't do this again. All right. It can be catastrophic next time. It's catastrophic now, but it can be doubly catastrophic. All right. That is all.
This hearing ultimately tells the story of repeated DWI offenses and the escalating consequences that follow. In the first case, the defendant admitted guilt to a felony DWI charge and accepted a 5-year prison sentence. In the second set of proceedings, another defendant not only faced a new felony DWI allegation but also admitted violating probation that had been granted for a previous DWI conviction. The result was probation revocation and another 5-year prison sentence running concurrently with the new case. Throughout the hearing, the judge repeatedly emphasized a central theme. Every prior conviction matters. What begins as one offense can evolve into felony charges, probation violations, and lengthy prison sentences when the same conduct continues. The court's warnings reflected concerns not only about legal consequences, but also about the dangers impaired driving poses to the public. What do you think about these outcomes? Were the sentences appropriate given the defendant's histories? Or should repeat DWI offenders face even stricter penalties? Share your thoughts in the comments below. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.